So, yesterday, the Supreme Court heard the oral arguments for whether former presidents have immunity or not. And the arguments were very long and convoluted. Let's break it down here. Welcome to Law and Society. If you're new to my channel, please like and subscribe, and let's get down to it. First, a couple of things stand out for me. First of all, the Supreme Court generally gives like half an hour for each party and then some 10 minutes or so for rebuttal. Yesterday's oral arguments went for 2 hours and 39 minutes, and there was no rebuttal. So the justices pressed Donald's lawyer for about an hour, and then the government's lawyer, Mr. Dreeben, for about an hour and a half. They had a lot to say because this case is extremely important, not just to this case, this particular case, but also to the larger general principles that govern our republic, and the separation of powers, and the powers of the president, and the power of the judiciary to say what the law is. And so what I'm going to do is, what I did this time, I sort of just went down how each justice asks questions, and then went by the order of seniority in terms of Justice Thomas being the most senior one and Justice Jackson being the most junior one. But the biggest thing that stuck out for me, to which I, sort of pulled the whole whoa, really, was when Justice Barrett's questioning of Mr. Sauer, Donald Trump's attorney. And at the outset, Justice Barrett clarifies that private acts don't get immunity. And Mr. Sauer concedes, yes. And then she starts reading the indictment. And there are about 3 or 4 statements that Justice Barrett reads. And each one of them, Sauer concedes that what the indictment alleges is they were alleging private acts. And so I went, okay, so you have just conceded that pretty big portions of the indictment as it is being read are private acts. And so for me, the question of how the court will look at this concession is a big point. And, so that's why I wanted to start with that and point that out. And now what I'm going to do is I'm going to go through the questions that each of the justices asked by the order of their seniority. Justice Thomas started out asking Mr. Sauer, the petitioner, Donald Trump's attorney, about the source of the immunity and how exactly does it come from the Constitution. And Mr. Sauer says it flows from the executive vesting clause. Well, the executive vesting clause does not explicitly say anything about immunity. And we'll hear that later from Mr. Dreeben, the government's attorney, that there is no immunity statement for presidents in the Constitution. When it came to asking Mr. Dreeben, Justice Thomas starts out asking, there's no immunity, so you're saying there's no immunity for official acts? And Mr. Dreeben qualifies it, saying, yes, but the position is that the president, as head of the Article 2 branch of government, can assert Article 2 objection to criminal laws that prevent exclusive powers or prevent president from carrying out constitutionally assigned functions. What Donald Trump is asking for here is blanket immunity. And what Mr. Dreeben said is that there's a procedure here where the executive branch can object to laws because of the exclusive powers given to the president and because of powers that allow the president to carry out constitutionally assigned functions. So that blanket immunity that Donald Trump claims is not necessary. So that's what I got from Thomas's questioning. He questioned Mr. Sauer about the special counsel not having authorities. Mr. Sauer said that they weren't arguing that point here, and then wanted to talk about why weren't previous actions of presidents prosecutable, and there. Mr. Dreeben says that there are statutory constructions when there's serious constitutional question, and they get advice from their lawyers before taking action. And then there's the OLC public authority exception to liability that is read into federal law unless Congress takes action to oust it. So that's how Thomas sort of asked brief questions. Cannot give you an idea of what Thomas will rule, but if I were to give Thomas and not know anything about Justice Thomas or any of his other controversies, I would say that based on the questions and his professed ideology of textualism, it is not a convincing argument that the executive vesting clause is where presidential immunity flows from when the text doesn't say anything to that effect. So I'm very up in the air about what Justice Thomas will do, but he has often ruled with the conservative majority no matter what the outcome of the case. He seldom has a big position to take. But I hope that, he would look at it from a textualist perspective. Have a quick drink of water here. So thank you for being here with me. And if you're new to my channel, please like and subscribe. I am doing a little upload experiment now where I'm not live streaming because with the live streaming videos, there's a lag. And so I am recording these and then publishing these in YouTube premieres. I'll go back to live streaming at some point in the near future. Let's get back to the summary. So the Chief Justice then asks Mr. Sauer an analogy about an ambassador being appointed as ambassador for the bribery of giving $1 million. So the bribery is not the official act, but the president appointing the ambassador is. And so that question sort of turned Mr. Sauer around, and he said the indictment in this case goes to the core powers of the president's acts. And, he doesn't really, that's not what the brief says. That's not what any of his briefs have claimed, that they were the core powers. In his last response, Donald Trump made a very audacious claims that his official activities were intertwined with these claims of alleged private acts. So, private aim is criminally liable, the Chief Justice says, and Mr. Sauer says that in order for that to happen, the court would have to expunge the official acts that are part of the indictment. Then, when asking questions of the government, the Chief Justice was kind of a little negative. How easy is it to get the grand jury to bring indictment with reliance on good faith of the prosecutor? So here the Chief Justice is inferring something that maybe the grand jury was corrupted or somehow, they didn't look at the facts so much as the good faith of the prosecutor. So Mr. Dreeben says that politically motivated prosecutions are illegal and that there are several safeguards for unfair prosecution. Mr. Dreeben then says there's no immunity in the Constitution unless this court creates it today. No textual immunity. Despite the fact that the framers knew how to put immunity into the Constitution. They have the speech or debate clause about legislators, but they did not have anything about the president. And the reason that Mr. Dreeben provides is that the framers were aware of the big risk of presidential misconduct, and it was a big concern for the framers. So, the Chief Justice asks some peripheral questions, and it seems to me that the Chief Justice is the deciding factor here, where he's saying here, talking about private acts and saying that somebody's criminally liable, and then also discussing the likelihood that the prosecution may somehow be not in good faith. It's kind of a little playing the devil's advocate. With Justice Alito's questioning, I didn't find anything that was big on Mr. Sauer, but there was a lot of questioning that was done about the the integrity of the process, about the integrity of the Attorney General, and it is like So Mr. Dreeben said there are layers of protection from politically motivated prosecutions. The Attorney Generals can be trusted to act in a professional and ethical manner. And the question then asked by Alito is, how robust is that protection? Points at corrupt Attorney Generals in the past. Then Mr. Dreeben says grand juries will shield from groundless prosecution. And Justice Alito questions how robust is that? And so there's a big, Justice Alito kind of questions Mr. Dreeben about the veracity and the integrity of the prosecution itself. Mr. Dreeben says prosecutors have no incentive to bring case if there's no evidence. It's baked into the Constitution that any POTUS knows that they're exposed to criminal prosecution. That's a common ground here, that they knew that they could be indicted. From Watergate to today, and Watergate cemented that idea that former presidents can be indicted. So if POTUS gets advice from the Attorney General that something is lawful, is there an absolute defense? Asks Justice Alito. Yes, entrapment by estoppel. If government representative says that what you're doing is lawful, it would be a violation of due process to prosecute for that crime. But then Mr. Dreeben distinguishes and makes it a point to say to the court that this is a once-in-history prosecution. So, and then they jump around some more, and Justice Alito asks about the pardon authority, and Mr. Dreeben says there's no self-pardon authority because a person shall not be judged in their own case. So then you go into the more esoterics. What does a stable democratic society functioning require? It requires that candidate who loses an election leaves office peacefully. But what if a POTUS loses and knows it's possible that they will be criminally prosecuted? Will that not lead us to a cycle that destabilizes our country? Mr. Dreeben says there are lawful mechanisms to contest results in election. That Donald Trump, petitioner, filed dozens of challenges, lost all but one, and did not have any evidence or proof of election fraud. So the question of Justice Alito's were more slanted and skeptical of the integrity of the prosecution, which somewhat was striking to me, that the justices were questioning the integrity of the prosecutors and the prosecution. Quick drink of water. Next, we go to Justice Sotomayor. Where does immunity power come from? Qualified immunity, reasonable person standard, what a reasonable person would do. So, to instruct the jury that there is no liability for official conduct, but yes, for private acts. So, she sort of has this conversation about, the president, ordering the assassination of the political opponent, and then Mr. Sauer says, there are many safeguards to that, and the military wouldn't follow order. And when it came to asking the government questions, Justice Sotomayor said, if we say the president cannot be included in a criminal law unless explicitly named, that would mean that Senate could not convict based on any high crimes or misdemeanors, because that means he isn't subject to the laws at all. If not covered by criminal law, he can be impeached for it. That's what Justice Sotomayor says, and it's a big problem, and Mr. Dreeben agrees here. Only thing in the Constitution about the president and laws is a relationship of the president to take care that the laws be faithfully executed. So it's hard to imagine the president breaking the law is faithfully executing the law. Mr. Dreeben says, the ultimate check is goodwill and faith in democracy. Crimes here are antithesis of democracy. Justice Sotomayor says, no man is above the law, either in his official or his private acts. Mr. Dreeben confirms and says that is an assumption of the Constitution. So Justice Sotomayor sort of brings it back to the case and talks about the particular case and the harms of granting somebody absolute immunity, and how, and then brings out in Mr. Dreeben how there's no man who is above the law. Then we go to Justice Kagan. And Justice Kagan goes back to the allegations in the indictment like Justice Barrett did. And that also kind of throws Mr. Sauer off. And he goes back to saying part of core recommendation clause power. And when talking about the alternate state of electors. And so Mr. Sauer here is talking about, Justice Kagan kept giving examples of selling nuclear secrets, and Sauer said it may or may not be official acts, and talked about staging a coup, and he said guidelines prohibit military from doing that, but the president would have to be impeached and convicted first. So these are very outlandish hypotheticals, and he gave very outlandish, audacious answers, saying that, essentially that you couldn't prosecute a president who did all these things unless he was first impeached and convicted in the Senate under their theory. Then Justice Kagan says framers did not put an immunity clause into the Constitution. They knew how to, but they didn't. And that also goes back to what I was reading from Mr. Dreeben when talking about how there's no immunity, there's no textual immunity. So for the textualists in the court, it would have to be a question that if it says there's no immunity in the text, then where are we getting this immunity from to begin with? So Kagan starts out with Mr. Dreeben with saying the core functions are absolutely immune. Then you go into the next category, which is still in the world of official action, and then you look at the statutory construction rules. Different from just saying it doesn't say POTUS, so don't apply to POTUS. No serious constitutional question whether he needs to engage in bribery to carry out official actions. Misuse of official power for private gain is prosecutable. Does it raise a serious question that infringes on POTUS's powers? The answer: that's the main question in prosecuting POTUS. Fake electors plot is not official conduct. That's campaign conduct. Donald's lawyers conceded many private acts that are in the indictment. Removing acting AG, Mr. Dreeben looked at it as an aggravating factor in the prosecution because pressing the DOJ to send false letters to states, DOJ said that they was not true and it wouldn't do that. And that's when Donald threatened to remove the acting AG. So the question here is about the DOJ being complicit is one of the means of going about the conspiracy. So then Kagan talks about what about the Georgia phone call, and that was as an office seeker, not as an office holder. And then communicating with the VP, the question would have to be, what was the context of the question as an office seeker or as an office holder? So going on to Kavanaugh, asking Sauer, what did this DC Circuit go wrong? And it said it adopted a categorical view that there's no immunity. The source of the immunity is not explicitly written in the Constitution. That's what Mr. Sauer says. That's what the court, that's where the position is, that it's not in the text. Kavanaugh, so then going on to Kavanaugh asking Mr. Dreeben, the government's attorney, questions. POTUS has to make very hard decisions. Do you think he makes mistakes? Isn't he in a special position? And then Mr. Dreeben says, yes, he's in a special position to access to legal advice, constitutional obligation to be faithful to the laws and the Constitution. And making a mistake is not what lands a president into criminal prosecution. In this case, conspiracy is conspiracy. The law in this case is about functioning of the country. POTUS has no function in this case in regard to certification of the rules. This is very important. The president has no role in that proceeding. So then Justice Kavanaugh says he's focused not on the here and now, but also the future, because, he's being, bigger than himself here, without any reason to do so. And then goes on to sort of question the structure of the independent counsel. And so couldn't really get to the merits of the question, couldn't really talk much about immunity. Acts not with an exclusive power, there's no blanket immunity, but for various considerations, Congress can legislate specifically for POTUS to be liable. And the answer to Mr. Dreeben says, executive has balanced protection that serves the Constitution, accountability and protections for POTUS. Gorsuch talked about private conduct can be prosecuted, and Sauer conceded, yes. Gorsuch then talked about the core powers that are beyond review, which is the pardon power, recognizing foreign nations, the veto power, and that's it. So Gorsuch also makes the superfluous assertion that he's thinking about future cases too. We are writing a rule for the ages. That's not egotistical at all. So I started out with Justice Barrett, and Justice Barrett talks about, I told you already with Mr. Sauer, and essentially dismantled the case before this argument even got started. And Justice Barrett asked Mr. Dreeben about the public authority doctrine, justifying conduct that is required or authorized by law, defining the duties of officers, any other provision of the law imposed by public duty. Objective facts were determined in that test, and it's an absolute defense. What about state prosecutions? Dreeben says supremacy clause issues if determined that immunity derives from Article 2. Private conduct here, integrated conspiracy that had different components. Private lawyers to achieve goals, official power to make conspiracy likely to succeed. So the court should allow the official aspects to be entered as it bears on the knowledge and intent, and cannot be taken as, part of the criminal acts. So Justice Barrett is, I believe, the one who could possibly be the one who causes this court to take note and hold that former presidents don't have criminal liability, or that presidents and former presidents don't have immunity from criminal prosecution for private acts, and in cases where they are entangled, then the district court has to go in on a fact-finding mission. I can see Justice Barrett going in that direction. So, Justice Jackson, lastly, absolute immunity for official acts, right? Asks Mr. Sauer. Determination is whether acts were official acts. How do you determine what is an official act? When using trappings of the office or personal gain, that is not an official act. What was up with the pardon of Nixon? Sauer says Nixon was being investigated for private and official acts. Why would POTUS not be required to follow criminal law when performing official acts? Sauer, he's required to follow the law. If POTUS isn't chilled, the most powerful person in the world goes into office knowing there would be no penalty for committing crimes. What is the disincentive for turning the Oval Office into a seat for criminal activity in the country? So these are some powerful questions that talks about what would happen if you would turn the Oval Office into a bed of criminal activity. And Sauer says Congress has to speak clearly before regulating core presidential authority. Again, we're not talking about core presidential authority in this case. Then going to Jackson's questioning of Mr. Dreeben, private acts are sufficient for this case to proceed. Even if some acts were immunized, because of private acts, the case should move forward. That's a yes. Justice Jackson asks, and Mr. Dreeben says yes. Statutes in this case applies to whoever or any person, so there's no ambiguity. Then Mr. Dreeben says there's no core acts alleged in this indictment. POTUS's actions, then Justice Jackson and Mr. Dreeben have a discussion about POTUS's action being chilled by guardrails of liability after leaving office. But what if there was no accountability? What would happen, asks Justice Jackson. And the answer is, it would be a sea change to have immunity for a president that no president has had or needed. So, and then Mr. Dreeben says that we have a functioning system based on Nixon and this case. And earlier, Mr. Dreeben made the point that we have structural systems that allow for the truth to be assessed. And that is their argument. Now, what was really weird to me was there was no rebuttal. Usually there is a rebuttal, and Mr. Sauer said he had nothing else to add. And I think as it were on the law, as it were with the arguments and the briefs, there's a clear and as with the concessions made by Mr. Sauer, there are big portions of the indictment that are private acts, and over those private acts, there is no immunity, and the core acts, the core presidential acts of the veto power and the power to pardon and then recognize foreign nations and appointments, these powers are not in question. What is in question are other powers that are not enunciated in the Constitution, that are in sort of comes from the vesting clause, that the powers of the executive branch are vested in the president. So for textualists, it should be pretty easy, but that's not what Gorsuch and Alito and Kavanaugh indicated. So, I would see a 6-3 opinion saying that remanding the case back to the district court for the criminal trial, where there will be instruction of first assessing whether there was any purely official acts. If there were, to take those out. Then if there are acts that were commingled, and then if they're commingled, you see if they were commingled to be the cover, the official act being the cover for the criminal act, for the private act, and then presented to the jury to be assessed whether those private acts are criminal acts based on the statutes. So that's what I'm hoping that the Supreme Court will rule. So we'll just have to see what happens. And if you have any questions about this, please comment and I will do my best. There are certain parts of this argument that sort of went over my head, and you may have heard that in my narrating of the notes that I took. But hopefully I got this 2.5-hour behemoth down to half an hour, so as to make a little bit of sense and see which direction the justices were going. I think Kagan, Sotomayor, Barrett, and Jackson seem to be on the side of not granting immunity. I don't think any of the justices want to grant complete immunity to former presidents. So it'll be interesting to see what the ruling is. With that said, thank you so much, and I'll talk to you soon.